Hey, everybody. If you haven't joined us before, the drill is we let the participants join, and we usually get started about 5 minutes after the top of the hour. So just hang tight, grab a Coke or a cold drink, and we'll be getting going here in a few minutes.
John, do you want to say a word about our question and answer tonight while people are waiting?
Yeah, as you guys are joining, we usually try to keep this thing to an hour. I think last week we had 650 questions. We were able to get to a little over 300 during the session. So what we're going to do at 9 o'clock Eastern is we're going to kind of stick around and just answer questions. It'll be a lot of silence unless John Lucas sees something that is a theme and we can address it verbally. So the program will be over at the top of the hour, but we will continue to be here and answer questions. So you can start your Q&A. If you have questions, we'll try to get to them. We have a lot of people in the background helping with that. So I have 7:03. We're going to get started at 7:05. But I'm not in the Eastern Standard Time. I'm in Central.
Hey, John Humphrey, someone's asking, did you catch any fish last weekend?
No, we didn't fish. We worked pretty hard.
Hmm.
We had a lot of opinions on what we could and couldn't say. And I think we had to do four takes of that video.
I do want to, somebody asked where we were in Arkansas, and I want to give a shout out to Lone Oak. Is that how you pronounce it, John?
Lone Oak, Arkansas.
I've never been to Arkansas, and it's a really pretty state.
Okay, we got about another minute or two before we get going. All right, let's go ahead and get started. Bring down the slide, Deb, if you would, please. Welcome, everybody. John Humphrey, Chairman of the Tort Claimants Committee. I'm joined by a very special guest and my regular crowd, Doug Kennedy, Vice Chairman, John Lucas, attorney with BSCJ, Jim Stang, our lead counsel. In the background, answering questions, we have Steve Golden, Deb Grassgreen, and Rob Saunders. So we've brought in the Marines to help answer all your questions. And if this is your first time, I'm very excited to announce a guest that we have, Michael Johnson, who knows a lot about youth protection at the BSA. And so that's going to be the gist of our topic. He served as 10 years at the Boy Scouts, trying to improve and fix that program. And we're going to be asking him some questions. So we're going to break down the night into three parts. The first will be Q&A with Michael. The second will be, what do we want around non-monetary demands? We're going to go through a slide deck of 4 slides. And then here to answer your questions. So, Doug, why don't you welcome some of our first timers?
Yeah, I want to say welcome to everyone. A few reminders. We put up all these town halls on the TCC's website. That's tccbsa.com. Also, we're catching up to technology. We've created a YouTube channel where we'll go ahead and put our videos up. So we'll put that link on the tccbsa.com website as well. The questions, we continue to take questions, and we really enjoy reading your questions, and they're shared with the members of the TCC. So that email address is always put up at the beginning and end of these webinars, as well as also I should remind everyone, as John mentioned a few minutes ago, we're going to leave the question and answer up a lot later, even when we're done talking. So don't get too upset if we don't get to your question right away. We're going to have time to get to that. Okay.
So the funny question was earlier, did we catch any fish? We've had over 10, almost, I think, 10,000 views of that video
Almost.
since Sunday. And we just thought it was really important to respond to the videos that we saw. But let me make one thing perfectly clear. We want you to vote no on the plan, the way the plan is currently constructed. But we're fighting right now, even as we speak this week, to improve that plan. So we think a huge part of what you guys have told us is this non-monetary, and that's why we asked Michael to join us. But things are fluid. One thing I will tell you that, if you've watched the fun barbs between us and the coalition, is that we agree on protecting youth, and we agree on making sure that this never happens again, that no person, even outside of Boy Scouts, no child should ever be subject to the sexual abuse that we see in our society today. So much bigger picture. So we'd like to welcome Michael. We're going to talk about youth protection. We're going to talk also about voting. If anybody has any questions about voting, I know many of you already have. We will have another town hall next Thursday. I'm not going to steal Mr. Stang or Lucas's thunder, but we have a really exciting performance coming. We think we have some great information to share with you guys.
I think you can say what that's going to be, John.
You think?
You want me to do it, John?
Sure.
Okay. We've mentioned this in prior town halls. The TCC, working with its financial advisor called Berkeley Research Group, has done an in-depth analysis of 253 local councils, all of the local councils, including analysis of real estate assets, personal property, value of claims against that local council, trends in membership, revenue, expenses, and the like. And also an analysis of the camps that are available to the local council, the utilization of those camps, and in effect identifying the amount of excess real property. Starting beginning of next week, we are going to roll out the bulk of those analyses. And we're working on about 15% of them to try to make them more accurate. We have found some issues that needed to be updated. So check the website. They won't all hit on the same day because of just some of the technology. It'll be rolled out over a couple of days. But this will really illustrate to all of you the financial position of the local council implicated in your abuse and help you assess the disclosure statement. I think it's Exhibit G, John Lucas, that spells out the local council's proposed contribution, proposed by the local councils, as a percentage of their liability for the abuse. And this will fill in more detail about the assets available, not that just they're contributing, but the assets that we believe are available, while at the same time giving those local councils financial viability and functionality. So that's going to be something we will next week walk you through a local council presentation, because they're all in the same format. And you can understand what we're doing and appreciate, then you'll be able to look up your local council and say, okay, now I have a better picture of that potential defendant or claim target. So that's next week.
Great. Thanks, Jim. Doug, why don't you kick us off? And
Sure. Let me first say a couple things. Then it is first, I want to thank Michael Johnson for being with us tonight. I have seen so many emails from survivors that have all said the same thing, and that is they want what happened to them to never happen to anyone else. I've really been touched by how that's just a common theme. I'm not surprised, but it's such an important issue. And the TCC has been laser focused on what are referred to as the non-monetary demands outside of the money, making sure that the Boy Scouts reorganize to make sure the abuse doesn't continue. So one thing I want to kind of get to the 800-pound gorilla in the room, Mike, just a little bit. And that is, first of all, thank you so very, very much for coming out and being brave enough to sort of just open the doors to this operation. But one of the questions that survivors wonder is, what took you so long?
That is a great question. I left Boy Scouts in December of 2010 under interesting circumstances. And one of the things that Boy Scouts wanted me to do was sign a non-disparagement NDA, which basically restricted me from literally telling the truth to anybody about anything. I refused to sign it and walked away from money I feel like I was owed. Then it became pretty obvious, and I know how the organization works. I know I had a target on my back, and that I was kind of on my own. And again, I'm trying to start my own life over, if you will, in a career. But I wanted to tell the truth. Silence is complicity for me, and I stood on that, and other moral and ethical principles. And so then it became, what am I going to do? How do I go about this? And so eventually, after a little bit, I reached out to Jeff Anderson and Associates, and he said he would represent me. And I needed to have that type of representation, if you will, against an organization like the Boy Scouts of America or Scouts BSA in order to tell my truth. I had become fed up with the lack of progress and commitment to keeping youth safe in the organizations a good 3 years before I left. People there that I work with know that. But this is where we are here today, and I'm really happy to be here and honored to be having the opportunity to speak with you today.
yeah, we certainly appreciate it. We asked you to sort of take a look at the plan that survivors are voting on, and you've got as much expertise in this field as anybody. In your opinion, will the non-monetary portions do anything to roll back sexual abuse in the Boy Scouts?
No,
The way it's written today?
no, absolutely not. As a matter of fact, I feel pretty confident in reading it. It's pretty clear that Boy Scouts still retains the power in the sense of being able to decide what it is they should do or should not do moving forward.
Yeah.
If there is no
wise may consider. Yeah.
If there is no accountability, if there is no independent non-scouting accountability, if there's no complete transparent release of not only the IV files before they got scrubbed or reviewed or what have you, and Boy Scouts knows what I'm talking about, and any other and removal of NDAs and the non-disparagement agreements against numerous experts that are out there. And I know prior to my starting with Boy Scouts, as well as while I was there, you're never going to find out the truth about what has taken place and to begin the process of what needs to be done to protect kids moving forward.
Michael, that's a really important statement for you to come out and say that you don't think that this current plan is going to do enough. And we've had
Not even close.
We've had a few conversations, and I know you to be someone that wouldn't lie about that in any way, shape, or form. So yeah, you've been in this area for a long time, not only with the Scouts, but also had experience in the prevention of youth sexual abuse. What do you think are the most important things? And I know we could probably have an hour-long conversation on all of the things, but what do you think the most important things are that the BSA needs to do right away to stop the abuse?
So I will answer your question, but let me just add a little something. I'm a retired police detective who spent 24 of my 28 years investigating child sexual abuse. I was very good at getting victims of all ages to tell me what happened to them in detail. And then I was actually even better at understanding perpetrators, the whole gamut of sexual deviants, including pedophiles, and getting them to confess. That's a very core of criminal cases and then the investigation. So I just want you to know that's my background, okay? It's coming into this. So none of this, if you will, is a surprise to me. Here's the fundamental issue that Boy Scouts refuses to acknowledge that I was working on all the years that I was there, was that they're a high-risk organization. Plain and simple. When it comes to the actual perpetrators having access to boys and girls, youth, it is an issue of access and opportunity. And the Boy Scout still fails miserably when it comes to preventing individuals, sometimes known offenders, okay, which is sometimes the incredible part, from having access to youth in the program, via policies, procedures, follow up, and what have you. And that's at the very core of the problem. The Boy Scouts won't own that part of it.
So let's talk a little bit about the IV files.
Okay.
Have you seen them?
I
Is it
have.
possible for an independent reviewer to look through them and make sense of them?
So I have seen them. I haven't seen all of them. There's obviously a lot of them. If the Boy Scouts releases them, it's possible for an independent reviewer to look through them and make sense of them. Absolutely.
Do you believe there are names in those files of predators that are out there today?
Absolutely. Absolutely. It is pretty common practice. One of the first things I did when I got there after reviewing some of the litigation that had taken place, one of the major issues that Boy Scouts as a national organization was dealing with was a concern about failure to report law enforcement. And I was one of the ones that pushed to make sure any and all of the files had been, in fact, reported to law enforcement, because there's no tracking of that. And then we find out that many of them, I can't say vast majority, but many of the files had not been reported to law enforcement, or there was not enough information in the file to determine that. The files of today, after some major changes, do ensure that there is some type of notification. But there's still some.
What do you think it is? Do you think it's they're just worried about reputational risk, or it seems like they're more worried about being sued for putting the wrong information out there than they are for protecting kids?
You bring up something really important. It seemed that the files themselves they were more interested in the information in the files than actual protecting the victims. It always bothered me that there's more other superfluous information than there was about the victim and the family and any support, that can be given to them. But I'm sorry, what was your original question again?
Well, just, what do you think the reasons are that are,
are
there any legitimate reasons for not?
No. It's all about the brand.
Yeah.
Period. It is all about the brand and the perception of the brand for the organization and the protection of partnering, chartering organizations that are at the very core of the business model. Those are the big three issues. Okay. And if it goes against that, even best information from the top experts in the nation, which Boy Scouts had access to, it doesn't matter. If there's a perception that the brand is going to be hurt and endangered, and it goes to the bottom line of membership and money.
Michael, I was going to ask you what your general perception is of the Boy Scouts regarding sexual abuse, but I think you just answered that question. One of the things that surprised us, though, when you had when you came out and spoke, was in your mind, you believe that 50% of the abuse was youth on youth right now. And you motivated me to go on and take the youth protection training that anybody can take. And in that training, they mentioned that that's thought to be about 25% in the general public. So I guess my question is the Boy Scouts ignoring that it's twice as high in the Boy Scouts of youth on youth abuse? Or are they not aware of that? I mean, are you fairly confident that's what the number is?
Well, just a couple of facts. Number one of the responsibilities I had at Boy Scouts was consulting with Scout executives, camp directors, and field service directors of councils that are dealing with various incidences. It was very clear that over 50%, pushing 70, 75% of the incidences that they're dealing with are youth on youth or youth with problematic behavior issues. Number two, the only reason that these individuals will be calling the national office is if it was really serious, borderline somebody needs to be kicked out of scouting. In talking to camp directors, and I understand, John, one of you used to be working at camp or whatever, the camp people tell me they deal with 10 times that many issues with kids all the time. We're talking about what gets reported to the national office, which is where I was at. When you look at the youth on youth issues, you're talking about today's youth, streaming pornography, lack of supervision, older boys taking younger boys on outings without any adult supervision. You're talking about sometimes the chartered organizations and or their parents know certain boys have issues, whether they be criminal, cognitive, behavioral, or what have you. Yet these older boys, 16 or 17, are supervising or leading or what have you, 12 and 13-year-old boys. And then they have privacy in the tent with no, at night during these extended campouts with no adult supervision during the night. So the statistics from the training that you took are national statistics. What I was referring to is what's actually happening in scouting. I want to tell you, this is a true story. It's pretty amazing. When I first started bringing this issue up at the national office, the first general counsel I worked for, he wanted to make this out like it was a gay issue for certain gay youth. I go, no, this is not the gay issue. He did not want to focus on this youth exhibiting problematic behavior that we needed to focus on. He wanted to go that route, which was a major issue in discrimination of certain populations in scouting during that time period. So just to show you how deep it was, and all of these conversations are happening at the national level.
So do you think that the TCC can get the BSA to tighten up their policies and get independent oversight?
If you vote no, and you maintain your ability to require them to do the very things that we know needs to take place, and that is complete transparency of all their, beyond just the ineligible volunteer or perversion files. I'm talking about all research, release past experts like myself that have worked with them from their NDAs so they can speak freely about what they have talked about, what they've done, what have you, both internal and external documents. Then and only then will you be able to get a clearer picture of the problem, the magnitude of the problem. And once you do that, now we can start talking about with non-scouting independent experts what needs to be done to protect scouts.
Hey, Michael, we've got one more question, but again, we want to thank you so much. And after I ask you this question, if there's anything you want to add, please do. But we appreciate you being someone who's speaking out and is trying to keep this in the public eye, and your dedication to preventing sexual abuse. And we hope that you'll continue to do that. You mentioned that you've been in this field for a long time. We know that you've been having conversations with other organizations and know what they do. Are there one or two things that other youth serving organizations are doing that the Boy Scouts need to do immediately?
So two things that I will say to that. Number one, if a other youth serving organization has had an independent historical top to bottom review of their program, not paid for by the Boy Scouts of America, That would be a very important thing to do. But I want you to be real careful, because the Boy Scouts is real quick to say, look at all the great things we've done. And think of what it is, a lot of the great things that they're going to tout are things that I brought in the last 10 years. I don't know how else to say it, along with other experts and colleagues in the field. The Boy Scouts don't compare the Boy Scouts to any other youth service organization unless they camp from 2 days to 2 or 3 weeks, unless they have charter and organizations that are selecting their own leaders and not doing reference checks or properly vetting them. Unless, you know what I mean? Unless they don't have youth that are taking other youth out on outings and activities. You know, you cannot compare the program risks in the Boy Scouts of America with any other youth service organization, which is what they tend to want to do.
Yeah, that's a really important point that we have to remember. And in this reorganization, the TCC has really been focused on how the Boy Scouts can reorganize to make its mission and its operation more successful when it comes to abuse, not in comparison to another organization that isn't doing those things.
That's why you got to have those independent experts looking at all of the different programs in Boy Scouts and looking at the incidences and looking at any research that's applicable. Like we talked about the youth on youth, but then you got to look at what that looks like actually in the Boy Scouts of America. Then from there, you could begin with our basic knowledge of what some standard of care is, what needs to be done to protect, to ensure kids are safe. And then you need to evaluate. You need to research it to determine if it is in fact making a difference. I cannot stress this enough. Boy Scouts have been at this, 100+ years. You can't trust them to do it themselves. They are they're incapable of doing it. And if you look at the current structure,
I think culturally they're stuck. They've got too much go along to get along, too much cultural inbreeding, and nobody willing to risk their neck to make a change. Well, listen, Michael, we just really appreciate you being here tonight. Happy to have you stick around. We're going to kind of move with our theme of non-monetary and youth protection. And we're basically going to outline a 4-point plan that we would like to see in the plan. So thank you once again for attending. Thank you for your courage in coming out. And we really appreciate your support.
It's my honor. Thank you very much for everything that you guys are doing. Good luck.
Thank you.
Thanks, Michael.
Okay, Deb, you want to bring up our slide deck? We got lots of questions flying in. I think we've answered about 160. And we're going to keep going even after we finish this part of the presentation. We're going to continue to answer questions. So hang in there and keep asking. So I'm going to sort of summarize what we're going to talk about, and then I'm going to turn it over to Doug. Doug is kind of the architect on our team of the non-monetary demands. You know, it's funny how we have this amazing team of people, everybody with different skills. It's almost like the U.S. trustee was like a savant in knowing what we needed, because the right people have showed up when they needed to. So, you know, we really believe that, as you heard us talk about with Michael, this oversight of youth protection is critical. Validating the data and creating a mechanism for public reporting, including the report that they make to Congress, dealing with the ineligible volunteer files, and then finally, governance. So with that, I'm going to turn it over to Doug, and Deb, you can go to the next slide.
Thanks, John. So let me just say that this is not a laundry list of the things that the TCC wants to see the Boy Scouts to enact. This is a framework. This is just the oversight, just the 10,000-foot view, if you want, to get at some of the things that a lot of people have been talking about. So one of them is categorized under level of oversight. And what's really needed is an independent standing body with not a 3-year term limit, but with no term limit, that's going to be responsible for measuring and reporting abuse on an ongoing basis. We need an independent standing body. And when I say we, I'm not only talking about survivors. This is a reorganization in bankruptcy that's going to serve the public. So the public needs this body. It should be made up of survivors, experts in the field, and there are a lot of amazing experts out there. Also, BSA professionals and volunteers. We need a lot of eyes looking at this. The reporting is going to occur every 6 months for 3 years, and then annually after that. So we're going to have ongoing reporting as to how the abuse is being eliminated. We don't think after hundreds of years of history of this and 82,500 claims that we can say after a few years, we're just going to forget about it and it's magically never going to happen again. And we also think that this body should be responsible for determining the actions the BSA must take to eliminate abuse. The Boy Scouts can consider all those and report to the public the ones that it agrees and is going to take. We want to give the Boy Scouts the opportunity to say, hey, these are the changes we're going to make. But also, just as importantly, we think that they should be able to explain the ones that they're not going to take. Next slide, Deb. The second piece of this is validated data and public reporting. So we've been dealing with too many secrets for too long. So we need to have data that's validated by a completely independent entity. The public needs to have confidence that the levels of abuse that are reported each year are the actual ones and nothing's being held from it. We also think that that data should be published to the Boy Scouts website, sent to every local council board member so they know whether or not there's any abuse that's been reported within their council. And again, that's just not the Boy Scouts paid employee, but the volunteer board members. Also, it should be part of the Boy Scouts report to Congress. Boy Scouts are very quick to say that they're a chartered organization, chartered by Congress. And since Congress serves the public and is elected by the public, we think they have a right and a responsibility to know that the public's children are safe. Next slide. The third portion deals with the ineligible volunteer files, and we think that all these files should be turned over to the Survivors Trust, and then we'll work with a mutually agreed upon third party that's going to determine which of these are valid files and which of them should be made public in a way that will ensure survivor and anyone else's privacy. We need to get these files out in the open. As Mr. Johnson reported, one of our incredibly big concerns is that not only that the people that abused us are still walking around out there unknown, but also that they've now gone and are started to volunteer and work with youth in other organizations, and that needs to be stopped. And our last slide. And the last piece of this is governance. And one portion of it is there a lot's been made of there being one survivor on the Boy Scouts board, and one voice in a closed door room of 40 people, we don't think is enough. And we think as the Boy Scouts board increases or decreases, it should be no less than 10% of its board members. And of that number, at least 50% should be not be present Boy Scout professionals or volunteers. So we think there needs to be an independent voice on that board as well. And then lastly, we think that the trust needs a sexual abuse survivors advisory committee. And that is going to advise the trust and keep an eye on the operation of the trust so that it knows how best to serve all of us, because these are our settlement that they're going to be managing.
You know, Doug, I'll add an anecdote, and it didn't come up during Michael Johnson's Q&A, but what we learned when we were talking to him is he reported to the chief legal counsel of the BSA. And if youth protection was part of the strategy of the Boy Scouts of paramount importance, you would think that that person would report to the CEO. And so I think that's telling about governance. So we really think they've got a long way to go.
So Deb, you can take that slide down now, I think. So, you know, overall, what we have here is we have a framework, everyone, that the details can be worked out by the experts, but we really want this framework to be sort of the four underpinnings and the foundation of what's going to happen moving forward. And it's based heavily on transparency and reporting so the public knows whether or not its children are safe.
So hopefully by now, you all know how to vote. If you have not received a ballot from your attorney, you should have requested one. If you need to know how to request a ballot, if you go to TCC BSA, there's a big red button on that homepage that says request a ballot. And we just want to make sure that, it's not vote yes, vote no. There's three things in that ballot that you have to vote about. And I'd maybe like to turn that over to John Lucas to cover those things.
Okay, yeah, happy to. Thanks, John and Doug. Just want to say that we have a lot of general voting questions, and while we're urging everybody to vote no, we just want to say that we still have a lot of time. The ballots need to be at the voting agent in their hands by December 14th. So we have some time. And so if we do something on voting next week or the week after, please, we're trying to get through as much of this as we can. But here's a couple of questions, and I'll go through them and I'll answer John's question. People have asked, my ballot is 22 pages long. They gave me an envelope to send back my ballot, but I can't fit all the pages in the envelope. So here's the answer. Pages 1, 5, 6, 8, and 17, and that's the one you sign, all go back into the envelope. You could throw out the other ones. We'll put some sort of FAQ, a frequently asked question, on the TCC website to let people know. We've been getting a lot of questions about that, and Steve and Rob have been answering that question here over the past, basically today was what really came up, and we got confirmation that we could do it that way. Got another question today was, how do I vote online? And so what that means, or the answer to that question is, there isn't like a web page that you could go and input your name and make your selections and then hit send. What you'll need to do is, if you have a paper ballot, you'll need to scan it and you'll have to upload it to the website. And there's a link on the Omni website, and the link is in our page that we have on our TCC website about how do I vote. And that's the medium to do that, or the way to do that. But really the simplest way of how do you get your vote there is to make your selections, put it in the envelope, and mail it to the address. And that information is on how do I vote on the page on our website also.
John,
And-
can I interrupt for a second?
Yeah.
I have heard that there have been some communications from the coalition saying that an app is going to be rolled out that will enable people to vote. You and I have talked to Omni directly, and there is no alternative platform for voting being created through an app. It is possible that this app, as I've heard it described, is a way for people to communicate with their counsel, who will then tabulate that vote on a master ballot. But if you get an email that says, this is your ballot for voting, that is a communication between you and whoever has sent it, but is not the way you cast your vote directly with Omni, You either are going to do it the way John described, put it in the mail, or you're going to communicate with your attorney, who will tabulate your vote on a master ballot. But there's no third way of doing it.
Yep.
So Deb, before you bring down that screen, I saw a question in there. Where can I see John and Doug's video? Well, there it is on tccbsa.com. It's also out on YouTube. Are there any other themes of questions that you're seeing, John, that?
Yeah, hey, we'll put this up on the website, but I'm going to say it again. Which pages on my ballot do I return? So here I go. I'm going to say it again, and I'm going to say it a little bit slower, but we'll put it up on the website. by tomorrow too. Pages 1, 5, 6, 8, and 17. So that's pages 1, 5, 6, 8, and 17. And so, you have, the key thing there on your ballot is, do I want to accept the plan, or do I want to reject the plan? That's the key, one of the key thing, obviously the main primary piece of your ballot. And, obviously the TCC is recommending that you reject. And the next piece is whether or not you opt out of the voluntary releases. And there are a lot of questions generally on that. And what that means is, other than your sexual abuse claims, do you have any other claims that belong to you personally against, let's say, the Boy Scouts board of directors or officers? Most of you probably don't even know the answer to that question. And maybe even most of them are, maybe you don't, but opt out, because it doesn't hurt to opt out. If there's any doubt, just opt out. It doesn't affect what you're going to otherwise get. The other provision in the ballot is, do I want to make the $3,500 election and be done? And if you want it, you could vote accept or reject on the plan, and vote to get the election. And for 30, but if you don't want the election, you just leave it blank and you walk away. But you want to return that page though, even though it's blank. And then finally, there'll be a page there where you put in all your personal information, your name and your address, and all the other information that it asks for. But crucial, sign the ballot. Sign the ballot. So
Jim, I saw a couple of themes in there, and Doug and I tried to address this in our video about does a no vote mean years of litigation and delay? And you've been doing this for many, many years. Why don't you hypothesize, if the no vote goes through, how long it will take and what that work might include? And then also talk about if the other side starts to worry about whether they have the votes to win, how they might be more accommodating to some of the things that we're after. So maybe you could address those two things.
Okay. So everyone's trying to get the early exit polling to see how the voting's going, because on some issues, it shouldn't matter. And I'd say there's really, we have started very preliminarily additional discussions with the coalition about child protection. This is not an issue that I can imagine we would have differences with the coalition on, because everyone wants to protect children. And Michael's comments about the institutional priorities of the Boy Scouts is an aside. I'm talking about how the plaintiffs groups align on that issue. But the exit polling, if there is such a thing in this case, is really about how far one can push the other. Because while voting is not the sole issue the bankruptcy judge looks at, it is an important issue. And we are going to get interim voting reports through the TCC, and other parties who are interested in the case will be able to get interim voting reports. We've been promised that. But we have no way of knowing how many votes ultimately are going to come in until the voting deadline has passed, because people, for one reason or another, might hold master ballots till the last few days. But the process of negotiation is ongoing. And attendance at these town halls is an important indicator of interest. How many people have viewed the videos is an important indication of interest. And I think Doug or John, you said is it up to nearly, is it over 8,000?
Close to
I think it's 9,700 right now.
Okay, no, it's pretty good. And that keeps on increasing. That has not plateaued, folks. The word is getting out that it exists. And the word is getting out that these town halls exist. The disclosure statement package, solicitation package, we call it sometimes, should have been received by people by now. It certainly has gone out to all the lawyers, and it has gone out to those who wanted to have their communication sent to them directly. And so if you don't have your voting package yet, if you haven't heard from your lawyer, you should definitely contact your lawyer, because that voting package, unless the Postal Service has really let us all down, should be in their hands. And if they have it and haven't forwarded it to you, they undertook the responsibility pursuant to a highly negotiated process with the court to get those to you. And time is clicking. Now, we all know that you can see the plan by going to our website. You can see the disclosure statement by going to our website. Our letter recommending a no vote, all of those are available to you if you have the facility online. So I can't speak for any given law firm and what it's done or hasn't done, but I saw a question on the Q&A saying my lawyer told me there's some delays in getting it to me. I can go to Kinko's and print these things off, folks.
Yeah.
Well, I don't get it.
Jim, one thing I
But
want to say.
I want to
though-
answer the rest of John's question, but go ahead, Doug, John Lucas.
Well, I mean, just one thing though. One thing that I know that certain law firms are doing is that they're trying to prepare sort of an informational summary that they could send to their clients that might include a recommendation.
Okay.
And so, I mean, I know that because people have shared some of them with me and I've looked at some of them. And so they're, saying, hey, this is what the plan, it's 400 pages, and we're trying to sort of distill this down to the essence so that we can advise you and make you aware of all the important things in the plan. And in the end, we might be recommending X or Y. So please tell us what you want to do. And so I think that might be some of the delay associated with some of them, but still, they should all be able to very quickly, at the very minimum, send you, electronic links to all these documents so that you can begin reviewing them. So.
At a minimum, look, I stand corrected, and I certainly don't want to fault people for adequately informing their clients, but I understand the anxiety here, and people should at least know why they haven't heard. And so I would encourage people to communicate with their clients, whoever the law firm is that's representing them, let them know what the ETA is on this stuff. Because while we say there's plenty of time, people are anxious and they want to be able to hold on to something and make a decision. But I certainly encourage every law firm that's out there that has clients to make sure that these materials, which are complex, are understandable, so they can make an informed vote.
Yeah, one thing I want to say, Jim, is I'm reading emails I received, is I think there is some confusion out there about, am I going to get a ballot? Am I going to be contacted by my attorney? Is there something else that's going to happen this way? And, at the end of the day, I think sometimes this comes down to, if you have an attorney, that's a question you have to ask. How is my vote going to be cast? But John Lucas, at the end of the day, if a survivor says, you know what, I want my ballot, I want to touch it, I want to feel it. This is something I've been waiting decades to do, to cast a vote. This is simple as sending an email to Omni, right?
It is.
So, and on our website, that's that red button you push, but oftentimes that will bring up your email program and some people's phones and everything else. So we're going to post that website. It's just BSA ballots at omniagent.com with no E in agent, which is right, John?
Yes.
Yeah, that's a little weird. So, yep, there it is. So we'll post that somewhere it's prominent, but anybody today can send an email just to that address and say, I want my ballot.
Yeah. And that email information that's right there is in our form called How Do I Vote? So,
but again, but I want to be clear here. The TCC has been recommending from day one that you discuss with your attorney your individual situation. And I've done this, John's done this. We've chatted with our attorney and say, how are we going to be voting? How are you going to cast our vote? But if you can't do that, you're not comfortable, you don't want to do that, there are other options.
So let me
Right,
answer
so,
John's
yeah,
question
I
about,
want you to answer that question
Yeah,
about
I'm
this.
going to.
Are we going to go on forever? Because I think
Right.
people are nervous that a no or a reject vote is going to result in, a litigation that goes on forever.
well, the answer is, in my opinion, no, you're not going to wait forever. The scare story for people who are saying that is that everyone goes back to their own corners and takes all their money with them. So Hartford, we know, we can talk about Hartford because it's a publicly announced deal, will take its $785 million and say, we're never paying a penny. Forget about the 785 we offered yesterday. And we're not going to talk to you, and we're going to expect you to litigate your individual claim against our insured. The real world doesn't work that way, folks. Any of you who have ever negotiated anything knows that a no is often just the word you say before, but how about this? Now, you can say, Jim, your opinion, but let's talk about two, we've used them before, well, one of them before, real world examples in the bankruptcy system. In the Archdiocese of St. Paul, Minneapolis, the debtor filed a reorganization plan and the creditors committee filed a reorganization plan. The survivors voted no against the Archdiocese plan, and the survivor plan, for various reasons, didn't get approved by the court. People didn't go back and fight for years against the Archdiocese. They went to a continued mediation, and within, I wasn't the attorney involved in the case, but shortly thereafter, relatively speaking, shortly thereafter, a deal was cut that survivors supported. No one went off to their corners and pouted for more than a day. They came back and renegotiated. But let me give you the second example, which is even more relevant to what we're talking about. Judge Silverstein is the bankruptcy judge in the Boy Scout case, and she presides over a case called Imerys. Imerys was, in effect, the sole supplier of talcum powder to Johnson & Johnson. And Imerys was getting sued for ovarian cancer and mesothelioma as a result of the use of the talcum powder. Its reorganization plan went out for vote. That reorganization plan did not pass. Did the insurance companies who were objecting to the plan take their money and go home? No. What did they do? Well, within the last 48 hours, those insurance companies filed a motion with the bankruptcy court to appoint a mediator. I guess they didn't have one in Imerys. Those very insurance companies who supposedly are going to go to the four corners of the earth and never be heard from again, in a mass tort case involving severe personal injury, they said, now let's go back to the room and talk some more. It's only going to get better. It's not going to get worse. One might say, if that's possible, but it's not going to get worse. It will only get better. That is my opinion. I think it is people's gut. People who say otherwise, I don't think are accurate. And the real world examples in the bankruptcy world, where one might argue deal making is king, for better or for worse, it's not what happens. So a no vote means, after 24 hours of going, oh my gosh, what are we going to do now? I have no doubt we will be back in the mediation rooms, and the leverage of survivors for the best case possible will be enhanced. Because if there's one thing these folks want, be it BSA, local councils, chartered organizations, or insurance companies, is finality. One thing we hear time and time again, the insurance companies never want to hear the phrase Boy Scouts again. They want to be done with this. And if you tell them that $785 million isn't going to get it done, they will find a way to get it done.
Jim, what is the percentage that the BSA and coalition would have to get with their votes for the judge to say, yep, they won? I
Well,
know there's other issues,
for
but
the package of releases and resolutions that they want, it is no less than 75%. There is no hard and fast rule for this kind of mass tort case. In an asbestos case, where asbestos is the agent that caused the harm, there is a specific kind of Chapter 11 case that requires creditors vote at least 75 of the creditors voting, at least 75% support the settlement. That percentage is being used by people to say, well, that's probably the percentage necessary in a sex abuse case. That is just a rule of thumb that people are using, but it is not a hard and fast rule. The court might require that the percentage of yes votes be much higher, but people are using a working assumption that it can't be less than 75%. But it might have to be more. We just don't know, because a mass tort case of this proportion with this kind of disagreement over the proper solution has not occurred to my knowledge.
so we're going to continue to answer questions. We've answered 300, over 300. We still looks like we've got about 144. So what I think we're going to do, Doug, is we're going to go through sort of our normal wrap up, and then kind of go on mute and just keep answering questions for the next 20, 30 minutes if people want to stick around and ask. You know, I got a few things to say, and then I'll turn it over to you, Doug, to close us out. You know, people ask us all the time, you know, do you have a plan? What do you want? And we've been very clear about that. And if the coalition and the BSA could get movement on these three items, we could be satisfied and support this plan. Number one, as we talked about tonight, the two big elements are youth protection. You know, I think the coalition joins us in this. I think every parent in America supports every youngster that's in organized sports or travel sports or community organizations or churches, that we stop abuse of children. And that is what we want from the BSA. We want independent review. As Michael said, they haven't fixed it themselves. They need some help from the outside. And there's lots of flexibility that we have there. We think the IV files are a no-brainer. They have to be reviewed and redacted, and they need to be published to an independent review. That's number one. Number two, we think there's billions more. I think they talked about in their press releases close to 1.9 billion. Like, that's a historical number. It's historically low when you think about 82,200 claimants. We think there is a substantial amount more money that the local councils could put up. And that's what we're going to cover next week when we review the dashboards and you guys get to see a few examples. We think the sponsoring and chartering organizations want a hall pass for no dollars. We think that's completely unacceptable. And we believe there's a path to the insurance companies making a contribution. So we think we know where the coalition is going to end up, and we think we can do 30 to 50% better monetarily. And then the last thing that is extraordinarily critical to us is that when this trust is formed and the monies go in and the process starts, we think it's extraordinarily important to have an independent trust administrator that is not in the game, so to speak, and that they have they report to the judge or the court, not to a group of lawyers. And so, and then there's some mechanics of how the trust operates and how it could save some money, and those things are really important. So, you know, we're three things away from a plan that we might support. So one of the questions was, is there mediation going on? Yes, there is. We can't really talk about where we are, but it's yesterday, today, and tomorrow. It's been pretty intense. So, and there's been some interesting movement. So it's obviously covered by mediation privilege. So more to come on that. So that's what we want. We don't want to run the BSA out of business. We don't want to destroy the local councils. We just want what's best for survivors. Doug?
Yeah, John, I think you really stated it well. Just the only thing I want to add to that is on behalf of all of the TCC, we get your emails, we debrief after this meeting. The 9 of us chat, we email and text each other on a daily basis. And I want to thank every single survivor for your strength. It's your strength that's keeping the 9 of us going, because we know how important this is to you. We read your concerns. We know how passionate, how hurt you are by some of it. And I want to thank you for being strong. I do want to say that it concerns us that some people try and scare survivors into saying that this is going to drag on forever. And we think that that's really playing off of the concern of every survivor, that they want to get some resolution. And I'm going to ask everyone, every survivor, to all that strength that you've had over the years and decades, you still have to be strong now. And you have to be strong to make sure that your vote is counted the way you want it to be counted. If you agree with the TCC, that's great. If you disagree with us, you know what? We want you to still make sure that your vote is cast. And we want you to have the strength to make sure that your attorney is going to listen to you and vote your will as well. But we don't want you to be scared. We want you to know that the 9 of us are trying to do the very best thing possible. And we don't think anyone should be scared right now into thinking that if they vote yes for this, it's their only path to ever seeing any money. So stay strong.
Yeah, so we're going to, John Lucas, I'm asking you, are you going to address any big trends on the Q&A, or are we just going to go mute and just answer them online? What's your thought right now? You're muted.
John, you're on mute. Maybe that's an indicator.
Thank you. Yeah. I had one of my kids coming up trying to get me to sign one of their homework things. When I had no idea what I was signing. So I said, go away for now.
Well, there's a lesson. Don't sign something you haven't thought of.
Yes. So I haven't really found, there's a couple, I want to say that there are a couple people, a handful of people there, and maybe more than a handful, that are frustrated that we're not getting to their questions. We have gone through and answered almost 400 questions right now. And so we're trying to get through to everything here. And so, be patient, or send us an individual question at bsasurvivors@pscjlaw.com. Just go to our website at the tccbsa.com and you can send us a question there. Some of the questions that I saw earlier tonight was, is there going to be a list of abusers that's published? And my response to that was, I don't think so. I don't, or at least the very minimum, the plan isn't going to publish the names of the abusers. Let's say, for example, that John might have put on his proof of claim, because John's proof of claim is confidential, and so that's not being made known to the public. And I know that that's sort of frustrating to a lot of people. I think that in some respects, I think a lot of survivors want to know if the same abuser abused other people. And so we've got a lot of questions like that, but I haven't seen anything that would provide sort of that information at this time.
John, let me just address that for a moment. And I know we may lose some people, but if we're going to keep this open, maybe we can answer questions. And I saw a question that I wanted to answer as well. In the Catholic Church cases, which I am very involved in, the church has created a standard called credibly accused. If you're credibly accused, which is the result of an internal church review, many dioceses and many religious orders list those men, the names of those men. I think it's the unique relationship between especially Catholic clergy and the bishop and the diocese that gives the diocese the cover in effect to be able to do that. But very, and it's sad, it's unfortunate, it's actually tragic that so many of these people have not been criminally prosecuted, which of course is once notified is in the hands of the authorities and not in the hands of the Catholic Church or the Boy Scouts. Again, once notified, it's very important. And there are concerns that perpetrators will litigate the issue of defamation as a way of kind of defending themselves. And we've seen that happen in the church cases. But I think there's a unique relationship there where people go, well, the church is doing it. Why can't the Boy Scouts do it? It's a different relationship between the volunteer and the Boy Scouts and a Catholic priest and his bishop. The other thing that I have seen on the Q&A, someone wrote, I was sexually assaulted many times, and the matrix says I'm going to get $2.7 million. Well, folks, we've talked about this before, and I want to be really, really clear with you. That matrix tells you what the value of your claim may be. It does not tell you how much you're going to get paid. The Boy Scouts have said, this is in public documents, that the abuse claims range from a value of $2 billion to $7 billion. The future claims representative has said that the claims are $25 billion. And we think the number is higher. And there's a whole chart in the disclosure statement that shows that under the current settlements, you're going to get 10 cents on the dollar. Now, of course, as the value of the settlements go up, your percentage could go up. But please do not confuse the value of your claim and what you're going to receive on that claim. That's why we talk about percentages on the dollar. This is something that I keep on seeing in the Q&A, and it's all about how much the claims are worth. And we're working on that as part of our presentation of our opposition to the plan, and how much money is coming in. Because if the claims are worth $7 billion, that's the Boy Scout high-end range, and the settlement is $2 billion, $2 billion, then you're going to get, I don't know, someone do it quickly for me, about, not quite 30%.
Yeah.
If the claims are $25 billion, that $1.8 billion settlement gets you a lot less. So value of your claim versus the amount you're going to get paid. Fractions, amount you're going to get paid on top, value of your claim below. So I'm sorry if I'm beating a dead horse on this, but I'm still seeing questions about that suggest some confusion between valuation of the claim and what you will receive on account of the claim.
So I've tried to answer this other question that I've seen, and so I'm going to try to give it. Somebody asked about a timeline. We know that we're in the voting period and that the votes have to be in by December the 14th. We know on December, 27th, we'll know what the votes actually were tabulated. We know that on the 24th of January, there will be a hearing where the judge will look at the votes. The parties will make legal arguments. And if it's clear, she'll rule. If it's not clear, she'll put people back into mediation. So our feeling, and this is a John Humphrey opinion, so is that we're not that far off. And it is likely that if we go through a no vote, that within 48 hours, we'll be back around a negotiation table, and it'll probably extend the bankruptcy 60 days, but certainly not a year. And certainly, yes, by this spring. If we get defeated and there's a yes vote, and it is 75%, as Mr. Stang says, then whatever the BSA and the coalition have cooked up, that's the deal. And it gets confirmed during the hearing, assuming the legal arguments aren't overwhelming. And it is our belief that they might be. Then, it could be done by February.
And let me
So-
just, well, while Jim thinks about that, let me just add, it's not a John Humphrey feeling. It's a TCC feeling that all of us are like every other survivor. We want a resolution to this for sure. We want a resolution. We just want a fair resolution. That's all.
Right. And look, I've been looking at numbers all day long. And I think based on what I've seen in press releases, that the coalition is a little aggressive on how many claims they actually have. And so I think it's going to be interesting to see how this voting comes down. And I believe that this is going to push people back to the negotiating table even before the middle of December. So
Yeah,
be
John, on
patient.
the timeline, the hearing will start on January 24th. We don't know how many days she has reserved for us. And in the world of civil litigation, that's what this is, even though it's in the bankruptcy court, you don't necessarily have serial days. It might be the 24th, 25th, and then we has other matters and she'll pick up again the following week. And so we don't know how long the trial will be because we're still in the early processes of getting documents exchanged and taking depositions, and we'll see how that all plays out. After the bankruptcy court rules, if she rules in favor of confirmation, the Boy Scouts want to go to the district court, in a sense, a superior court, a higher court, and get that court to affirm her decision, to confirm the plan. And in Delaware, which is where the bankruptcy case is is pending, that could take, we're told, about 30 days. It's not a whole new trial. It's kind of a review by the district court judge. The projections that we see when the Boy Scouts talk about its financial condition, when it emerges from bankruptcy, are March 31 projections. Now, can it get out sooner? Sure. But right now, the projections stop at around at March 31st. I'm not going to necessarily contradict John or Doug about how long it'll be to put Humpty Dumpty into a better egg, but it will happen very, very quickly. And the Imerys case is a perfect example of that. Within, I think, a week to 10 days, the insurance of the plan being voted down, the insurance companies went to Judge Silverstein and said, appoint a mediator. So just look at the real world. Look at what really happens and decide the risks associated with a no vote, which we recommend.
Thanks, Jim. I appreciate that. And, you've been at this for 4 decades. So it's one of the reasons why the TCC retained your firm was for that kind of experience. In the time it's going to take me to ask the next question, we're going to go over 400 questions answered. 400 questions answered. So I want to thank all your staff for doing that. But here's a question, and it's one that I want you to address. There have been a number of people that have asked, how do I get rid of my attorney? They're not answering my phone call. They won't help me for, how do I get rid of them? And I think there's a lot going on there. There really is, related to whether or not that's a good idea, whether or not you should, how you would do that. And I think it's important that question be answered from an attorney.
Okay. We're not picking on anybody here.
No, and I want to be
right.
clear about that. These are people that are unhappy with their representation, plain and simple.
This is the way you do it. You write to the attorney, and an email should be sufficient, that you are terminating the relationship. If you have a copy of your retainer agreement, which I hope people do, you should make reference to it by date. You should also make reference specifically to the law firm. Yeah, I, so-and-so, hereby terminate my legal relationship with you and your representation of me, you don't have to write this down word for word, but you get the gist of it. With your representation with me, period. This is very important. I think every state in the country has this provision in the rules of professional conduct. I demand that you immediately provide to me a copy of my file, because you need to know what's actually been done for you. And the only way you know that for sure is to ask for a copy of the file. You are entitled to it. You are entitled to it, I'm sure, under your engagement agreement with the law firm, and you're entitled to it under certainly, every state I've ever heard of. Once you have done that, you have severed the relationship with that law firm. You have to deliver it, of course. It would be a good idea to call the law firm, though I appreciate communication is part of the problem you're describing, and get to the highest level you can get. I want to talk to an attorney, and tell that person, I have sent an email to whatever your email address is, and I have terminated the relationship with your law firm. So verbal, make a note to yourself that you did it and when, and you have an email. If you want to have a replacement lawyer, your replacement lawyer will engage with your now fired lawyer to enforce your rights to copy the file. And that lawyer's job, the new one, will be to work out the fee split, because the fact that you have fired the lawyer doesn't mean that they're not entitled to any compensation. They may be. Are they entitled to, so let's just say you signed a fee agreement with a 33% contingency. Are they entitled to the whole 33%? Well, no, I don't think so. But it really is the job of your new lawyer to deal with that. That shouldn't be on you. That's what the new lawyer's job is when you come in as the, if you will, the second kid on the block. So it's got to be in writing. You should make reference to your engagement letter if you have it. If you don't have it, you can still terminate the lawyer. You should demand a copy of the file. And if you hire a successor lawyer, he or she will want to see your communication because they want to be sure they're free to represent you, and let them handle the transmission of the file and handle the fee issue.
Thanks, Jim. I know that's a thorny subject, but it's important that survivors sort of know what their rights are in that regard. And I think we would encourage them before they take that action to really try and do everything they can to reach out to that attorney and make it clear that how frustrated they are.
I will say one more thing, Doug. If the survivor says, thanks, Jim, but I really don't want another one of you guys. I really don't want another lawyer. You can terminate the relationship without a lawyer, meaning without using one to terminate it. By the way, that letter, if you have a new attorney ready to go, they can write that letter too. It doesn't have to be from you. It can be from the new lawyer, if you will. They might ask you to countersign it. That'll be up to them. But if you decide I'm not going to have another lawyer, you're entitled to terminate. It's what we call an at-will relationship. You're entitled to your file. And when the time comes for your award, if you're challenging their entitlement to the contingency fee, all or part of it, you can take that up at the time with probably the settlement trust will have a mechanism, because the settlement trust will be sending out checks and that'll get worked out. But you don't have to get too, if you're not hiring another lawyer, the compensation part will get addressed. You don't have to do that today. And you shouldn't reasonably expect the lawyer who you've just fired to say, oh, well, I'll give up my fee. That's probably not going to happen. But you don't have to fret right now about the contingency fee, because at least for a while, you're not getting any money to be fighting over.
John Lucas, have you noticed any trends or anything that you want to?
Oh, that there's a lot of emails about, can I get a new attorney? Can I fire my attorney? Do I have to pay my attorney that I fire? And Jim just sort of went through that. There's a lot. I mean, we're up, we have responded to in one way or the other, I think about 500 in total now.
Okay.
And there are about 120 or so left here, and we're trying to go through them. But if we don't get to it here tonight, please send us an email with the address on the website at tccbsa.com, and our email address is there. And Steve or Rob will get back to you, or I respond to many of them too. And even tonight, I responded to everybody saying, hey, here's my email address, send me an email. So, we're not trying to hide or anything like that here. There's just really a huge volume of questions, and we're trying to do best we can here to get answers to your questions.
We've been averaging
John,
about
I saw
600 to 700 questions.
Yeah, I saw one question, and it had to go with what tier of abuse does my assault fall into? And that proof of claim form was heavily reviewed by Doug, John, and the other 7 guys. I mean, they literally spent, I don't remember how many tens of hours it was, and I'll say going over every word. And it was important to try to come up with these tiers of abuse, but how can you measure human depravity in categories? So someone who was penetrated may well have suffered in that very assault all of those conducts. Certainly you were groped, you were touched under your clothing. There may have been masturbation preceding the penetration. I mean, please, I don't want to have you relive your experience. So the question is, I checked all the boxes. When we evaluate the claim, and this is pursuant to the plan, and we don't disagree with it at this point, the highest or worst form of abuse you suffered is what's being measured. So in that sense, it's not cumulative. It goes to if I can call it this, the top of the list, if you will. And that's what's being assessed. So I did see some question that related that. I still see some statute of limitations questions about, especially which state is the statute, which state's statute is applicable. It is not the state where you live today. It is the state where the abuse occurred.
Yeah.
So people have theories that it could be Washington, D.C., because that's where the Boy Scouts are chartered. Some people, but it is generally speaking, and it's a pretty good generality, that it's where your abuse occurred. And then we also see questions, some people are hiring a lawyer for the first time now, some may be thinking about substitutes. Should I have a lawyer who resides or practices in the state where my abuse occurred? And I'll say that there are lawyers around the country who have in effect a national practice. They're situated in one place, but they represent survivors all over the country. And those lawyers who do that work, generally speaking, are excellent. There is something to be said for knowing the local color, if you will. Now, remember, our case is all situated in Delaware, and these TDPs don't have you in state court, except under certain circumstances. We're trying to make that more expansive. But these national law players often will associate with a local lawyer if they feel that that local knowledge is important. And so I've said this before, and I still believe it. You want not just a lawyer, if you will, my cousin Vinny. You don't want just a personal injury lawyer. You want someone who has experience in representing a survivor of child sexual abuse. And if you can find someone, and I'm not plugging any firm here, who's got BSA experience, that's a plus too. So if you, on the issue of local color, if you're talking to a firm that's outside of your state, ask them, do you represent people in California? How many cases have you had in California? You're a consumer of very expensive legal goods here, folks. You're entitled to have your questions answered by, in my opinion, by an attorney, not by a receptionist, not by a paralegal, but by an attorney. Because you're going to be dedicating upwards of, I've seen some fee agreements, 40% of your recovery to your legal representative. And you should know who you're hiring. So those are the questions I would ask just as a starter. And so there you go, John.
So
Humphrey.
We've been about 30 minutes over. We've answered well over 500 and there's still 130 open. So I think the more we talk, the more you guys ask, which is great. But I don't think we're going to make any progress at getting to zero. So
I have one thing I'd like to say again,
Okay.
and we'll put this up on the website by tomorrow. What pages should I send into my proof of my ballot? Pages 1, 5, 6, 8, and 17.
John, can I just comment? I mean, like you and I weren't the ones doing the mailing. It is somewhat beyond me that no one said, let's fold this thing up and see if it fits in the envelope. I mean, my God.
oh, I needed a
I
laugh.
got this little tiny envelope and this very big ballot, and maybe they'll just squeeze it in. I don't know. It's just, it's, you know, sometimes you have to laugh about human.
Well, listen, folks, we're going to get to the rest of these questions. We'll be putting together a Q&A and putting it up on the website. You guys know where that is, tccbsa.com. You also know that we have BSA survivors at pszjlaw.com. If you want to ask questions directly, I know Steve and Rob and team are looking at those things every day because they do forward some messages onto us. By request. So with that, I think we're going to end our evening. Hang in there, folks. We know this is hard. We know it's complicated, but we're fighting for you and we're making progress. So keep the faith.
Stay strong, everyone.
So long.
Good night.
Thank you, everybody.